the sentence remains a sentence of life imprisonment, but the court would be in a position, looking at all the circumstances of the offense and the offender, to say that by way of punishment, this is the minimum period that this person should remain incarcerated. But beyond that period, if it is, the person is no longer a danger to himself or to society, then he can be considered to be released. And under the legislation, then that aspect of it is dealt with by the parole board.
So is that a way of then reconciling this approach with the mandatory nature of the life sentence? Because one of the dangers you want to guard against, particularly in somebody who has exhibited a propensity to kill somebody else, is to make sure that at no point they present an unreasonable danger to the public. So is it then not consistent with imposing a mandatory sentence, but giving the judge the power and the obligation to demark a minimum period of time, and then giving to a better placed tribunal the function of deciding whether the person remains or is a danger to society?
That is certainly our position, Your Honor. The prisoner would have been convicted of what we consider to be the ultimate offense. He has taken another life. The legislation says that this warrants a mandatory sentence of life imprisonment, but now says that the court can determine by way of punishment, not that those words, of course, are used, but logically,
yes,
by way of punishment, that this is what would be appropriate in the circumstances. If, however, during that time, it appears that this person is likely to commit this kind of offense again, or this person has not taken sufficient steps towards rehabilitation so that there is a danger that is posed if this person is to be released, then the state should reserve the rights to ensure that that person remains incarcerated until such time as he no longer poses a threat.